Good afternoon, everybody. It's going to be a few minutes before we get started. Everybody's logging on right now. When you log on, if you're not already muted, please do mute yourself so that we don't get the feedback from your computer and or phone when you're listening. And we're going to get started, like I said, in a few minutes. This is wills versus trusts. We're going to go through the slides. And as we go through the slides, if you have specific questions, you can use the chat bar at the bottom, and you can join it. Sorry, having issues with the, there we go, admit all. Anyway, if you have questions, you can always go to the chat bar at the bottom, and you can ask questions. If you have something very specific that you'd like to ask, you can actually email me at dverni@herzoglaw.com. That's D as in dog, V as in victory, ERNI @herzoglaw.com. That way you can email me, or you can give us a call at the office at 518-465-7581. I'm in extension 122. I'd be happy to answer specific questions that you have. But if you do have generic questions that you would like to ask us, then you can email me or call me, or like I said, you can use the chat bar at the bottom, and we will try to answer your questions during the presentation. So this is Wills versus Trusts. I'm Debbie Verney. I am one of the attorneys at the Herzog Law Firm, and we're going to be going through the slides again. Like I said, if you have questions, you can use the chat bar and ask questions. And we're going to, actually, we got a little bit longer to get started. Some people are logging on a little bit late. So I did want to mention that, we have, look at that. We have a first question. How about that? Good question. So the question is, they have to leave early, and will it be recorded and available? I'm recording it right now as we're talking. It should be available on our website. And if this specific one is not available on the website, meaning me doing wills versus trust, we do have a lot of the webinars that are pre-recorded that are on the website. If you go to our website at www.herzoglaw.com, and you click on either the blog page or the seminar page, there's a bunch of the webinars that have been pre-recorded, so you can kind of watch them at your leisure. Again, this one is being recorded, but it takes a couple of days before she gets it up. And you will also receive a copy of the slides after the presentation. So I know a lot of people are taking very, very quick notes, and they're like, wait, I missed this, but you will receive a copy of the slides after the presentation so that you'll be able to compare them to your notes and look at what's going on. So again, Debbie Verney from Herzog Law Firm, one of the attorneys there. We have offices in Saratoga, which is where I'm coming to you from today, Clifton Park, Albany, and Kingston. And you can call our Albany office if you want to make an appointment. We are visiting with people in person. Of course, you have to wear masks and follow the rules. And we also are meeting with people via phone and via Zoom. So if you'd like to set up an appointment, which is a free consult, you just call our office and we'll get you set up. So without further ado, let's kind of go through the slides on wills versus trusts. So people are like, when should I start doing an estate plan? And anyone 18 or above should have an estate plan. So you're like, why would an 18-year-old need an estate plan? When my son went away to college, it was very important that he have a power of attorney and a healthcare proxy, and that I be obviously the power of attorney and healthcare proxy, because I wanted to be able to communicate with people in the college, right? If something happened to him, if there was documentation that needed to be signed. So anybody 18 above should have an estate plan. And a lot of times things happen. Even when someone's young, things happen. I had clients come in the other day that said, as soon as their son turned 18, they were going to do a healthcare proxy and a power of attorney for him because they had a friend who had a 21-year-old son that had a brain aneurysm and was unable to make decisions for himself, but because mom or dad or nobody basically had any documents for him, they were unable to make any decisions for him. They couldn't make any medical decisions. They couldn't make any financial decisions. And so therefore they wanted to make sure that they didn't fall into that kind of situation. So again, if someone's 18 or above, they should have documents. But if they become incapacitated, like this gentleman did, what if there's a disability? what if they pass away, right? Well, 18-year-olds, they don't have a lot of stuff. They may, you never know. I had a situation where um, I had a client that made their son do his estate planning documents, and he had a lawn mowing business, and he had a large insurance policy, and he ended up on a motorcycle accident and passing away. And thank goodness he'd done his documents, because we were able to save the family a lot of grief and take care of things after he passed away. So simple, right? Your simple estate planning documents whenever you're young, and then as you grow older, your documents can change. We always tell our clients they should probably look at their documents probably every 5 years. If something changes, obviously, then you need to look at them more often. Somebody that you've appointed becomes incapacitated or is in a nursing home, or someone that's a beneficiary passes, you may want to update your documents, but generally every 5 years is a good rule of thumb. So basic estate planning documents. So you just heard me talk about the power of attorney and the healthcare proxy. Healthcare proxy, living will, right? Power of attorney is the one that makes financial decisions for you if you can't make them for yourself. Healthcare proxy is the one that's going to make your healthcare decisions for you. And a will is the document that's going to dispose of your assets after you pass away. So we're going to go into each one of those in detail. So a power of attorney. So a power of attorney is a document where you appoint somebody else to basically step into your shoes. Once you've appointed a power of attorney and they've signed and you've signed, the new powers of attorney since 2009, September of 2009, in order for a power of attorney to be valid, the person that you has appointed, right, you need to sign the document and your agent needs to sign the document. They wouldn't be able to act without that. Now, if you have a power of attorney done before September of 2009, the agent didn't have to sign those. And then they redid the law again in 2010, but you still have to sign as agent before you can act. The ones that are grandfathered in before 2009, those are probably still fine. You might want to think about updating them because we're getting a lot of pushback from some of the banking institutions and saying that it's not a valid power of attorney. The new powers of attorney, you really need to make sure that you have what's called a statutory gifts rider, an SGR. It's a little thing you initial. And if you don't have a statutory gifts rider, the person you've appointed would only be able to gift $500. So you're like, well, why would I want them to gift more than $500? If, for example, you have a husband and a wife, right, and they're joint on a house, and then the husband has a stroke, he ends up in the nursing home, he's unable to make decisions for himself. If you have a power of attorney without a statutory gifts rider, he's not going to qualify for Medicaid because you can't get that half of the house out of his name because you can only gift $500. And obviously the house is worth more than that. So you need to be really careful. Look at your power of attorney right now. If it's done before September of 2009, you want to look at the gifting, right? So it's usually around M, and make sure that there's no limitation on gifting. A lot of the powers of attorney that were done before 2009 had a limitation of $10,000, which again, would make it very difficult for someone to transfer a house to their spouse. Look, I made a rhyme. Anyway, so again, best bet, if you have a power of attorney that was done before September of 2009, you might want to look at updating it. They're changing the laws again this year. They're going to try to make the powers of attorney simpler. They're still going to have the agent sign so that the person appointing them will have to sign and the agent would have to sign. If something happens to you and you don't have a power of attorney, we would probably have to do what's called a guardianship proceeding. That's a proceeding that it's very invasive, it's very expensive because the person petitioning for guardianship has to pay for the filing, and then they have to pay for the judge to appoint an attorney for the person that needs the guardian. And then usually there's somebody that may be fighting the guardianship. It's a very expensive, very invasive process. If at all you can avoid it, you really should. And we had a question, hold on. What is the difference between the power of attorney and a durable power of attorney? These are great questions, right? So a power of attorney without the durable part, right? Just a regular power of attorney is only good while the person has capacity. A durable power of attorney survives incapacity. So it just seems silly not to do a durable power of attorney because usually when the person becomes incapacitated, that's when you need to use the power of attorney. So the powers of attorney that people do at financial institutions, those are not durable powers of attorney. Those are powers of attorney that are only good while the person has capacity. Once a person becomes incapacitated, you're going to need a durable power of attorney to be able to act for that person. So what about a healthcare proxy? People are like, well, if I don't have a healthcare proxy, aren't they going to look to my next of kin to make the decisions for you? Not necessarily so. They're supposed to, right? So generally, it's not an issue whenever you have a healthcare proxy or you don't have one, right? You're rushed to the hospital, your next of kin comes in, they say, yes, no, do this, do that. And usually they'll follow their direction. But what if it's a second marriage, right? So what if the new husband is there and he's trying to make decisions, and now all of a sudden the kids come in and they're trying to make decisions? And unfortunately, if there's a situation where the people are arguing and there can't be a decision made, in the state of New York, the doctors and the nurses can make the decision, right? They can have a meeting and they can decide your care. So the best bet is put something in place that says who you want to make your healthcare decisions for you. What I generally tell my clients is after they've executed a healthcare proxy, that they should really take it with them to their next doctor's appointment, have them scan it into their file so that if there's any question. A lot of the doctors now are working in conjunctions with the hospital and have it up in the cloud so that if you're rushed to the emergency room, they can pull down your healthcare proxy. Okay, so the healthcare proxy can only act for you if you're incapacitated. Just remember that. So if you're sitting in your bed, eating your Jell-O, making your own decisions, then you're going to make your own decisions. This would be if you were incapacitated, or let's just say you had a stroke, or you fell and you were in a coma. These are the things people are going to make decisions for you if you're incapacitated. If you can make your own decisions, the doctors are going to look to you to make your own decisions. So what about a living will? A living will is your end of life. Okay, a living will is a document that says, hey, and this is generic language, right? Hey, if the doctor comes out and says, I'm not coming back, give me good drugs and let me go. I don't want to be on a ventilator. I don't want to be on a feeding tube. These are all language that goes into a living will. Now, a living will is not a DNR. A lot of people make the mistake and think that, oh no, I don't want a DNR. A living will is not a DNR. DNRs can only be done by doctors. A lot of the living will language would say, hey, if the doctor comes out and says, I'm not coming back, or I'm not going to have any quality of life, that I consent to a DNR, but it's not a DNR. And you need to realize too, that a living will doesn't have any teeth. Okay, so if you are someone's healthcare proxy and you're on their living will, and the doctor comes out and says, hey, on their living will, it says that they don't want to have a ventilator or a feeding tube, the person can override that and just say, no, I think, I've seen them come back from worse than this, they need a feeding tube. And the doctor's going to follow their direction. If you're very concerned about someone following your direction, number one, you shouldn't have appointed them. But number two, if you really want to make sure that things go the way they're supposed to, you really might want to think about doing a MOLST form. It's an MOLST. MOLST. It's a bright pink form. It's a form that you do with the doctors. If you're going to do it with your doctor, make sure that when you call in to make your appointment that you tell them that's what you want to do, because they're going to have to schedule extra time for it. And they sit down and they go through everything with you. And they sign it and you sign it. Now that has teeth. Does everyone need a MOLST form? No, they do not need a MOLST form. Classic example I give was my friend who had brain cancer. She wanted to make sure that she was not resuscitated. So she did a MOLST form, and basically it hung on her refrigerator so that if someone called the paramedics and they tried to resuscitate her, the person could give them the MOLST form and they would not resuscitate them. If you have a living will healthcare proxy and don't have a MOLST form and they call the paramedics, they're going to resuscitate you. That's the law. So last will and testament. That's what you guys are here for, right? If I have a will, do I need a trust? If I have a trust, do I need a will? Excellent question. So a will is the foundation of every estate plan, right? Because it gives direction as to where you want things to go when they pass away and who you want to get what, right? So not that many people have them, right? So 55% of Americans, they don't have a will, right? It's not necessary. My wife gets everything. My kids get everything. Most people just haven't gotten around to it, right? It's just not important. It's not urgent. What about, I don't think about it. I don't want to think about it because I don't want to think about death. Okay, there's what, two things in life that are going to happen, right? Death and taxes. So just because you do a will doesn't mean you're going to die, but you're going to die, so you should do a will. So what do we need to do whenever we're doing a will? So we need to figure out who the beneficiary is, right? Who are the beneficiary or beneficiaries? Who's going to get your stuff whenever you pass away? You can name as many beneficiaries as you want to, right? Generally, the will is kind of set into two different areas: your personal property, which is all your stuff in your house, your jewelry, your car, your furniture, and stuff like that. And then there's the residuary estate, which is usually your money, your property. And you can have different beneficiaries for both of those. Okay, then you're going to appoint an executor. An executor is the person that's going to collect up all the money and distribute it to the beneficiaries, is going to sell the house, is going to get rid of the stuff in the house that no one wants. The executor is a big job. So you need to make sure that someone that you appoint as executor is someone, number one, that wants the job. Yeah, I'm telling you, you should really talk to people and find out if they want to be your executor. And I always joke and say the executor should be somebody that can balance a checkbook. I know none of us balance our checkbooks anymore, but it's got to be somebody that has some financial background, because it's a big job collecting up all that money and then distributing it and make sure everybody gets the right amounts. You definitely want to make sure that you name someone that can do the job. So probate process. Now, what you need to understand, and we're going to go into this in a little bit more detail, is that if you do not have any assets individually in your name when you pass away, your will does not have to be probated. Okay, let me say that again. If you do not have any assets individually in your name when you pass away, your will does not have to go through probate. So what that means is if everything's joint, or it has a beneficiary, or it's in a trust, then your will not have to go through probate. The executor will never be appointed. So you need to understand that your will does not override your beneficiary designations on your life insurance, on your trust, on your retirement accounts. The will doesn't override any of that. If you have beneficiaries on accounts, those are going to go to whomever you've named. The will is not going to have any control over those. So make sure that, the best bet, name beneficiaries on everything, or make it joint so that you don't have to go through the probate process. It's not a big, huge deal, but it's expensive to go through the courts and it takes a while. So whenever someone's doing a will, I always love it when people go, can I go online and do a will? Well, yeah, you can if you want to. Will it be valid? Maybe, maybe not. So whenever you're signing a will, you have to have capacity to sign a will. A power of attorney cannot sign a will for you. A power of attorney can sign a trust for you, but a power of attorney can't sign a will for you. And they also can't sign a healthcare proxy for you. Kind of interesting, right? So whenever we're talking to someone, it's kind of funny because people are like, well, how do you know if a person has capacity? Well, generally, we ask questions of the person if there's any question as to their capacity. I had one situation one time where the client came in to sign documents, and the friend said, I really don't think that she should sign documents today. And I said, well, why is that? She seemed absolutely fine to me. She goes, ask her about my mother. Like, okay, so how's her mother? Oh, she's great. She came over. We had lunch. We went shopping the whole time. She's doing this, right? Mom's dead. Okay, so obviously it was not a good time for her to sign documents. She did not have capacity. Another thing, you have to have two disinterested witnesses to witness the will. What that means is these are people that are not taking under the will. If you have someone that you're giving something to in the will, you don't want them to be a witness, because if you do, they automatically don't get what you're giving them. So let's just say you do a will and you leave everything to your daughter, and then you have your daughter as one of the witnesses. Guess what your daughter's getting? She's getting zippo. She's getting nothing. So you need to make sure that you have two disinterested witnesses. And then there's what's called an affidavit of subscribing witness, which is an affidavit that the witnesses sign that says, yes, they were there, they watched you sign, and that you had your wits about you whenever they signed. Okay, pretty easy stuff, right? Now, this is the one that a lot of people kind of mess up on. No handwritten changes or additions. Do not, I repeat, do not write on your original will. If you want to write something on your will, make a copy and write it on it. Do not write on the original. If you write on your original will, you automatically voided your will. I've had people bring their documents in and they've lined out people's names, and I've been like, why did you do this? And they're like, well, she got married and her last name changed, or I don't want to leave anything to that person anymore, but I initialed it. It doesn't matter. If you make any changes, right, any handwritten changes to your will, you voided the whole will. So just those mere little scratch outs you did on the first page that added somebody's new last name or made other changes, you voided your will. You definitely don't want to do that, right? If you're going to make changes, make a copy of it, kind of write it up, but you need to make sure that you don't write on your original will. So what if you die without a will? Okay, so the state of New York basically is going to decide where your stuff's going to go. Sounds kind of silly, right? So what New York does is they look at the person, they say, do they have a spouse? Do they have kids? If they have a spouse and kids, the spouse is going to get like the first $50,000 and then half, and then the kids are going to get the other half. You're like, wow, that doesn't seem right, does it? And if they have no kids, it's all going to go to the spouse. So if they have no kids and no spouse, it's going to go up to their parents. No parents goes to brothers and sisters, no brothers and sisters, nieces and nephews. It goes all the way down to first cousins once removed. If they can't find one of those, guess where it goes? Yep, you got it, state of New York. So basically they drop a brick and whoever's head it lands on, that's who's going to inherit your stuff. And you think, well, that's not really a big deal. Well, generally it's not. But I've had situations, and I know I always tell horror stories while I'm doing this because I really want people to plan and I really want them to do their documents. So there's not the horror stories at the end. I had a situation where the husband and son came in to do the husband's estate planning. What had happened was the wife passed away and the wife didn't have a will. And they had transferred the house to the wife's name because the husband had a job where he could get sued. So they figured it was safer to have it just in her name. Well, she passed away, which you wouldn't think would be a big deal, right? So you're looking now and you're saying, okay, the spouse gets $50,000 plus half. Well, there were two kids. There was a son and a daughter. And so the son's like, no problem, Dad. We'll just deed the house over to you. And the daughter's like, I want my half. And they're like, this is mom and dad's house. The only reason this is happening is because we put it in mom's name. And she basically took her dad to court to get her piece of the house. So when he sold the house, he had to give her the piece of the house. I mean, that sounds like a far-fetched story, but we see things like this happen all the time. So that's why we try to make sure that you have your documents and that they say what you want them to say, because you want your assets to go to the right person, right? You want it to go to your spouse. I have a situation right now where the husband passed away and no will. He has a wife and a son, and all of the properties, and there were several, were all in his name, right? And there's not an issue with this son because the son's like, Mom, it's all yours, just take it. You don't need to worry about me, I don't need it. But it could have been a bad situation, right? The son could have said, no, Mom, I want my half. Or, what if the son has creditors? Right? Those could come crawling out of the woodwork too. So you got to be really careful. Make sure that you have documents and make sure that they say what you want them to say. So, as I said before, probate and non-probate property. Your will is only effective over probate property, meaning that if you make everybody a beneficiary or everything's joint and you pass away, and you wanted that $50,000 to go to that charity and you put it in your will, guess what? There's no money to go to that charity because it's all going to go to your beneficiaries. That being said, if you have a charitable intent, your retirement accounts are actually the best asset to leave to a charity because they don't have to pay tax on it, right? So if someone else inherits your retirement account other than a spouse, they're going to have to take it over the next 10 years and they're going to have to pay tax on it, right? Because it's pre-tax money. Whereas if you left it to a charity, the charity doesn't pay tax on it. So it's kind of a win-win. But anyway, I digress. I'm sorry. If everything's joint, so if you have a joint banking account, you have real estate that's owned jointly. Now be careful with this. If it's jointly between husband and wife and you bought it after you were married, more than likely it's tenants by the entirety. It means he dies, it's hers, she dies, it's his. If it's property that you purchased before you were married, and then the person dies, it may just be joint tenants. There may not be any survivorship, and you may have to probate that person's estate to get that piece of the property. Or we may have to do an heirs deed where all of the heirs sign off so that that person can receive that property. So we want everything to be joint or have a beneficiary or be in a trust. Now, whenever you have a beneficiary, you should always have a contingent beneficiary. So what does that mean? It means that if you have a retirement account, let's just say you name your spouse, you should have somebody else's backup, right? Because what if something happens to both of you at the same time? So a lot of times people will name their kids or their grandkids. Be very, very careful about naming minors as beneficiaries, because if you name a minor as a beneficiary of a retirement account, we have to do a guardianship proceeding. There has to be a guardian appointed, even if they have parents, right, to control those retirement assets. So when you're doing assets to a minor, be very, very careful. That's why we would want to set up a trust under a will or a trust under a trust, which is called a testamentary trust, so that that money would be held until these children become of age. So we kind of alleviate a lot of these problems with minors inheriting money. So what is a trust? Okay, so everybody's like, I hear about trusts, I hear about revocable trusts, I hear about irrevocable trust, I hear about living trust, I hear about testamentary trust. There's lots of different types of trusts. Okay, so when you're setting up a trust, there's someone that's going to be the grantor or the creator, right? And there's someone that's going to be the trustee. So if it's a revocable trust, you're going to be your own trustee. If it's an irrevocable trust, you're not going to be your own trustee. And then there's different kinds of trusts that are set up underneath that. Remember when I was talking about testamentary trusts? Those are trusts that are set up underneath a trust, meaning they don't exist until you pass away. So depending on what your plan is, you can have all different kinds of trusts all rolled into one trust, right? So you could have a revocable trust that when you pass away has a testamentary trust for grandkids, has a special needs trust for someone that has special needs. There's a lot of different planning methods that you could make. So when somebody says to me, so what if I just want a simple will, or what if I just want a simple trust? There's not really such a thing as a simple estate plan. Everything's different, right? There's no cookie cutter estate plan. So we really need to make them fit your criteria. So revocable trusts. Revocable trust is just that, right? A revocable trust is a trust that you set up as grantor. You put the funds into the trust, and you're also the trustee. So think of it as kind of like a box with no lid, right? So you're the grantor, you're the trustee, you're putting the assets into the trust so that they're kind of all in one place. So you're the grantor, you can move stuff in, you can move stuff out, right? The beneficiaries would be the people that are going to receive the assets after you pass away. And then you're also going to name someone as a backup trustee in case you pass away or you become incapacitated, right? So remember, revocable trust is a box that you put assets in. And why do we put assets in a revocable trust? For ease of distribution when a person passes away. For instance, if you have a house in New York and you have a house in Florida, revocable trust is an excellent thing to do so that when you pass away, the backup trustee steps up and says, here's your house, here's your deed for your house in Florida, here's your deed for your house in New York. You don't have to go through probate in New York and in Florida. It makes things a lot easier. So basically just what I said, but kind of a pretty slide. It says you're the grantor. Basically, you're the trustee too, until something happens, you pass away or you become incapacitated. You have to appoint a successor trustee, which is the person that's going to step up and take over if you become incapacitated. And you still have control, right? And just remember, because you have control, because you can reach in, reach out, reach in, reach out, a revocable trust does not protect assets, right? If you have to go into a nursing home or if you get sued by a creditor, those assets that are in the revocable trust are available to pay for your care or pay the creditor. So remember that. Revocable trusts, a classic example that I give, and if you've watched some of my webinars, you would know that this is a classic example I give. For instance, Mary Lou Whitney, who's been dead a little over a year now, if she'd had a revocable trust, then they would have not had to probate her will in Saratoga County. And those of you that have seen the papers a year ago, it talked about her will and about how different people got different things and everything wasn't even. If your will has to be probated, if it has to go to court, it becomes public record, right? So all that stuff became public record. If she had a revocable trust, the backup trustee would have stepped up and gone, here's yours, we're all good. Also, if you have property in more than one state, which it talked about her having property in Florida and having property in Kentucky, they're going to have to probate her will not only in New York, but now they're going to have to probate it in Kentucky, they're going to have to probate it in Florida. So you get the point, right? Cha-ching, cha-ching, ka-ching. If it had all been in a revocable trust, the trustee would have been able to step up, liquidate the assets, make the distributions, and they wouldn't have had to go through the courts, and no one would have known what's going on. So I always say this to people, if you're kind of curious as to when someone passed where all their money went, a relative, a neighbor, it's public record. You can go to the surrogate's court and find out exactly how much money they had and where things went. Definitely not something I want to happen whenever I pass away, but it's kind of fun if you want to go check things out. So an irrevocable trust. Now, irrevocable trust, a lot of people set these up to protect their assets. Sometimes they call them asset protection trusts. Sometimes they call them Medicaid trusts. There's lots of different names for them. A lot of people will set up irrevocable trust to protect their assets should they have to go into a nursing home. It also protects it from creditors. Now, when you're thinking about an irrevocable trust kind of think of it as like a box with a lid on it, right? So you put your assets in this box and it has a lid on it because you have to name somebody else other than you as trustee. And because you have someone else that's trustee, right, that has a lid on it. And that way it's protected in case you have to go into the nursing home. Now, I know you're looking at the next paragraph that says that they have to be created 5 years, right? So 5 years, there's a look back period for 5 years if you have to go into a nursing home for chronic care Medicaid, meaning that they look back 5 years for all transfers. So obviously, the sooner that you set up the irrevocable trust and transfer the assets to it, the better off you are. And there's a 2.5-year look back for community Medicaid. Now, if you have questions on community Medicaid, this presentation is basically on wills versus trust. We're really not going to go into community Medicaid or the specifics of Medicaid. If you really want to listen to those, you probably want to go to one of the aging in place webinars. We're going to go over that. Just kind of a caveat. It does say 2.5 years for the look back for community Medicaid right now. Actually, there's not a 2.5-year look back yet. Originally, it was supposed to start in October of last year, then it went to April, and now it's July. So as of July, there will be a 2.5-year look back for community Medicaid. So obviously, the sooner we get trusts set up and get going on them, the better off we're going to be. And I think we have a couple of questions. So hold on just a sec. If revocable trust created solely for real property, can or should successor trust to be the same person as the beneficiary of your home? Good question. That's strictly up to you. The reason we're doing a revocable trust is basically to make sure that whenever the person passes away, we don't have to probate the will, because you can't put a beneficiary on a deed, right? So I said, make sure everything's joint, make sure everything has a beneficiary, or it's in a trust. So if it's in a revocable trust, the backup trustee steps up. If it's the same person that's the beneficiary, then they just deed the property over to themselves or liquidate the assets and write them to themselves. So the same person can be the trustee, the same person can be the beneficiary, strictly up to you. Same thing on irrevocable trust. The trustee can be the beneficiary and the trustee can be the trustee. So trustee can't be your spouse. People are kind of disappointed about that. So it could be a child, it could be a friend, a relative. You reserve the right to change the trustee. So for instance, if something happens and you need to make changes to the trust, you can change the trustee. You can also change the beneficiary. So you're like, wait, so in New York, an irrevocable trust is revocable. Sounds silly, right? The way you can revoke an irrevocable trust, for instance, you can do what's called a partial revocation. So let's just say you have all this money in your trust and you want to take money out, you can do a partial revocation. And in order to do a partial revocation, you have to sign off, the trustees have to sign off, and the beneficiaries have to sign off. And what if they won't sign off? You can change the trustees and you can change the beneficiaries. So you still have control. Classic example, Harry Miller, who's one of the attorneys in the office, had a client who, and this is pre-COVID, by the way, her sister was dying in Italy. She wanted to go visit her. She said, I need to take $20,000 out of my trust. I want to go fly over there. I want to spend time with family. And so we prepared what's called a partial revocation. It's a simple piece of paper that says, I hereby revoke $20,000 out of XYZ trust. The only interested parties are the trustees and the beneficiaries. So she had 3 daughters, and it came back from 2 daughters, not the third one, which we always refer to as the evil daughter. So we called up the evil daughter and we said, hey, did you get the paperwork for mom's trust? And she said, yeah. We're like, well, are you going to sign it and send it back? And she said, well, mom's old. By me signing this is taking money out of my own pocket. To which we said, if you look at Article 9 in the trust, it says mom can change the beneficiaries anytime she wants to. So either you sign off or we'll amend the trust and take you out and see if mom puts you back. Next day, Federal Express, we got the partial revocation back. So again, you can change the beneficiaries and you can change the trustees. You can put your house in the trust. You still get all of your tax exemptions, your star, your senior star, your veterans exemptions. Oh my gosh. And you still get all of the benefits of your owning your own home. Unfortunately, you still have to pay the expenses. You still have to pay the mortgage and you still have to pay the taxes. You still get all the income that the trust generates. So if you put stocks or bonds or CDs or something that's going to generate income, you still get that income. So really nothing changes as far as that goes. Again, you can't take the trust principal out unless you sign off and the beneficiaries and trustees sign off. And at your death, everything goes out to whomever the beneficiaries are underneath the trust. So if it's structured properly after 5 years, whatever assets are in the trust are protected, right? Because that's the 5-year look back. If I'm looking for Medicaid to pay for my care, they're going to look back 5 years from the day I'm looking for Medicaid to pay for my care. So 5 years back from today, right? They look at all checking, savings, CDs, IRAs, 401ks, but whatever's in the trust, if it's been in there 5 years, it's protected and doesn't have to go to pay for your care. So kind of like trust versus will highlights. If you have a trust, there's no probate. You get to manage the assets during your life, whether it's revocable or irrevocable, because you still have control over the beneficiaries and trustees, right? So you can change it. It provides for incapacity. Your financial affairs become private, right? So you don't have to file the documents with the courts and no one really knows how much you had or where everything went. And it's harder to contest a trust than a will. So what about a will? There's probate costs and delays. We had a situation with COVID, right? Because the courts were closed. Luckily enough, it was spring and it wasn't a huge issue, but I mean, what are the questions? So if someone passes away and they have a will and you've got to probate it, you've got to find all these people to probate the will, who's going to pay the utility bills, right? Who's going to plow the snow? Who's going to take care of all those things while we're waiting to get appointed by the court? With a trust, the trustee just steps up and they take care of everything. So you really have a long delay with the courts. I mean, not so much now, but we were having months and months of delay during the beginning of COVID because we couldn't get anybody appointed. And it was very difficult for a lot of people. So obviously we want to avoid that. And we want to avoid inviting situations where people can contest the will. Your will does not come into effect until you pass away. I had a situation the other day where the person was like, but they put me on as a beneficiary of their accounts. I'm the beneficiary under the will. I'm the executor under the will. I'm like, well, they're still alive. So you have no control over their assets and you have no control over their will, right? They're going to pass away. Then you step up and have control. That's why you really need a power of attorney. So the person you appoint as power of attorney can also be the executor, can also be the trustee, can also be your healthcare proxy. Again, make sure you talk to the person before you appoint them for all those jobs, because you want to make sure it's somebody that actually wants to do it. Whenever you probate a will, again, we have to notify all these people and it gives them an option to come in and contest the will. The trust is never filed with the court, so therefore we're not going to have the issue with someone coming in and contesting. And we have another question. Hold on. Question. What happens if you don't put the house in the trust and instead deed it to the children? How does it affect the STAR program for an agricultural exemption? These are all such great questions. So this is actually one of my favorite slides that's not in this presentation. So the problem with deeding your house to your children, okay, let alone your exemptions, which I'll talk about in just a second. When you deed your house to someone else and you reserve a life estate that says that you're going to live in it as long as you want to, and whenever you die, it goes to the kids, you still get your STAR exemption, you still get your senior STAR exemption because you've got a reserved life estate. The problem with deeding your house to anyone, right, is that if they get sued, right, they could take your house. So the classic example I have is my mother-in-law deeds her house to my husband, right? And then my husband dies. Who owns her house? I do. My mother-in-law deeds her house to my husband, and then we get divorced. Who owns her house now? I do. You're laughing right now going, why? It's because I have a better divorce attorney, of course. My husband gets sued. Who owns her house now? The people that win the lawsuit. My husband filed bankruptcy. Who owns her house now? It's going to be part of the bankruptcy. So you have to be very, very careful. We're a very litigious society. You need to make sure that when you're putting your house in someone else's name, it's a big, big risk. We had a situation where it wasn't our client. They came to us afterwards. Lady in Saratoga deeded her house to her daughter with a reserved life estate. Her daughter lived up in Rochester, which was fine, right? Mom could live in the house as long as she wants to. She still gets her STAR, her senior STAR. And when she dies, it goes to her daughter. Well, her daughter died, okay? Her daughter was married and she had a will, right? But her daughter apparently was having an affair with another married woman, and in her will left her mother's house to this woman. So now this woman that mom has never met in her whole life owns her house. She still gets to live in it, pay the taxes and everything. But whenever she dies, that house is going to go to this woman that she's never met in her life. So not necessarily the outcome that she had planned, definitely something to think about. Also, if you deed your house to someone and then you decide you want to sell it, guess what? You can't do it. You're not in charge. You still have a reserved life estate that says you can live in it as long as you want to, and you could rent it out and take the rents, but you can't sell it, right? And so what if your kids say, okay, fine, you can sell it. The problem is that your kids get your basis in the house, meaning if you paid $50,000 for the house, that's their basis in the house, and now you sell the house for $450,000, they're going to have a $400,000 capital gain. That's not fun, right? That's a lot of tax to pay. So you really, really need to think about it before you deed your house to someone else. You need to think about it. I rarely will let clients do that. There's got to be a real big extenuating circumstance before I'll let someone do that. So what's right? What will versus trust, which is right for you? Basically, that's why we offer a free consult. We have you guys fill out what's called a client questionnaire, kind of like going to the doctors. You know how you have to sit there and fill out that questionnaire so they could diagnose you. That's what we want to do. We want to diagnose your estate plan. So we send out a questionnaire. We sit down with everybody, figure out who their beneficiaries should be, figure out who their fiduciaries are going to be, right? Who's going to be your trustee, who's going to be your executor, who's going to be your power of attorney, your healthcare proxy. This is all stuff that we would have to go over with you before we would determine what kind of documents you needed, right? So it's really kind of up to you at the end of the day as to what your documents are. You just have to decide what you want and where you want things to go. So when would you consider a trust, right? When are you thinking about trust? If you have property, right? If you have a house, if you have a house in more than one state, business assets, a lot of people forget about business assets, right? Do you own an LLC? Do you own an S Corp? Do you own a C Corp? What's going to happen to that corporation whenever you pass away, right? It's just not going to pass. We had a situation where a gentleman owned 50% of an LLC that owned a farm, and he passed away, and he didn't go back to the tree, right? No spouse, no kids. no brothers and sisters had passed away. We had to track down his nieces and nephews before we could probate the will, right? Not easy. And then it became planting season, right? And they needed to get a loan for seed to plant the seed. It was a mess. So think about those things. You've got business assets. What if you want to avoid probate? Definitely, if you can avoid probate at any cost, that's what you should do, because you really don't want to put your family through that. It's really kind of a pain. Protect your assets. Definitely, if you're thinking about if someone's going to sue you, or if you're going to try to preserve your assets, should you have to go into a nursing home, an irrevocable trust is definitely a good way to go. Avoid family conflicts, right? Because basically the trust spells out who gets what, and the trustee distributes the assets, and it's done, right? And also privacy. If you don't want your dirty laundry aired in the papers or aired at the courts, then a trust is generally the way to go. So this is the last slide. We do offer free consults. You can give our office a call at 518-465-7581. Stacy's at extension 126. She can make appointments for you. And again, that's 518-465-7581. Stacy can make appointments for you. Also, we have a radio show that's on every Saturday morning, if you thought this was fun, from 8 to 9 a.m. on Magic 590, and it's 1410 a.m. You can call in and ask questions. Usually there's 2 attorneys that are on, and we answer questions on estate planning, estate administration, and Medicaid planning. Also, like I said in the beginning, if you guys missed it, you have specific questions that you'd like to ask me and don't want to do them in the chat, it looks like we have another question. You can email me at dverney, it's D as in dog, V as in victory, ERNI, dverney@herzoglaw.com. I'd be happy to answer your email questions. We do have webinars the rest of the week, Tuesday through Friday, each day at 2 o'clock. Tomorrow is how not to pay for services. I got an email earlier today and that says, does that just have to do with Medicaid? No, it doesn't. There are services that are available to seniors, whether you're on Medicaid or not. It's a great program that's done by our geriatric care manager, Kim Hance, to tell you all the things that you could be eligible for. A lot of people don't realize that they're eligible for them. On Wednesday, it's a new webinar. It's estate taxation for dual residences. So kind of going back to the people that have houses in New York and have houses in Florida. How are you going to be treated for estate taxes? How are you treated for income taxes? It's a great webinar. It's, like I said, it's a new one. Jane Marie Schaefer is going to be doing that one. That's a new one this week. That's on Wednesday. Thursday is legal and financial planning for people with Alzheimer's. It's done in conjunction with the Alzheimer's Association. It's an excellent webinar. Definitely very educational and really a lot of good information. And Friday is estate and Medicaid myths, which is always a fun one. It's kind of like Mythbusters, right? You see that on TV, Mythbusters. Well, you know, my cousin told me this or that about estate planning. They said I don't need a will. So that's a lot of fun. So those are webinars that are on this week, each day at 2 o'clock. And then we also have webinars every Wednesday that we're not doing the webinar week. We have webinar Wednesday that we have webinars at 10 a.m. and 2 in the afternoon. And if you'd like to join us for any of those, you can go to our website at www.herzoglaw.com and you can click on them and you can register, or you can call our office at 518-465-7581 and we can help you get signed up for them. And it looks like I have another question. Let's see. Oh, not a question. It says thank you, which is nice, right? So again, it was great sharing this time with you. Happy President's Day. And if you have any questions, feel free to reach out to the office and ask any questions that you have. And oops, hold on. So you guys enjoy the rest of President's Day. It looks like it's already started snowing out there, so stay safe, right? And if you have any questions, feel free to give us a call or shoot us an email, or on Saturday on the radio show, reach out to us and ask questions. It's always fun. The radio show is always fun because you don't have to necessarily ask questions. You can just kind of listen to everybody else's questions. And then a lot of times that spurs other questions. So we'd love to hear from you. Give us a call. Take care now. Bye-bye.